Okay, good afternoon. Let me have each of you make your announcements for the record. Let me call the case P-37302. This is in the estate of Alberto Rene Montoya. Make your announcements, please.
Your Honor, Ruben Ramirez here for Alberto Rene Montoya Jr.
Howard Reiner, attorney ad litem for the minors.
Nancy Hamron, attorney for State Farm Fire and Casualty Company.
Tomas Flores on behalf of Doris Delio Rios.
Christy as the successor administrator of the estate.
You want to tell me what you have pending for hearings this afternoon?
Yes, Your Honor. I had filed a motion for status. I think most of the items have been taken care of. The deposit of the money by Ms. Rios was deposited. I noticed there was a listing for one of the properties on Bryan Road, which was a concern because it's a not community property.
I'm just asking what motions you have.
Okay, the motion for status.
Motion for status.
And then a motion to depose Doris Rios.
Okay,
Those two.
okay. So Flores, do you have any motions pending?
Yes, Your Honor, I have a motion for protection and a motion to compel.
Okay. Any other lawyers making appearance here have any motions pending requesting affirmative relief?
Yes, Your Honor, I have an application to pay attorney's fees that was filed on June 26th.
Okay, I'm surprised to hear that, Mr. Ryan. You haven't been paid?
No, we split my fees, Your Honor. So the order was signed for Ms. Rios to pay part, and then the remaining part was to come from the estate. So it's two different applications.
And what part remains pending?
The one from the estate.
Is that like an agreed order? Has everybody agreed to the amount? And
I filed it and gave notice to everybody back in May, and it was agreed that I would file these in the settlement agreement. It was agreed that I'd seek the rest of my fees from the estate.
okay, I don't know why I had the impression that had all been granted and signed with.
I haven't seen the order.
To Mr. Reiner's, do you have a proposed order that everybody has seen, Mr. Reiner?
Yeah, it was sent to everybody on May 25th.
What was the amount that was going to be paid by the estate?
$9,235, Your Honor.
Any objection from anyone? Mr. Ramirez, I guess you're the one I should ask first.
Well, one clarification, Judge, that was part of the agreement for the mediation agreement, but then I think they were thinking that there was going to be two accounts. There was going to be a division of money for the estate and money for Doris Rios. And then you decided to say, no, it's going to be one account for the whole estate. So I don't know whether the estate is now responsible for part of that fee or not. I mean, it's a little confusing for me. I don't know if it's not confusing for everybody else.
Mr. Reiner, can you clarify?
Your Honor, I understood it was to be paid by the estate because I did give benefits not only to the minors, but the entire estate. I've already received a portion from Ms. Rios. That was $3,617.41 that came out of the surcharge suit. So it was my understanding that the remainder would be paid from the estate, not Ms. Rios as part of the estate. So if the court decides it wants to pay out of the whole pot, that's fine too. It's court's decision.
I don't make a distinction between payable out of the estate and the whole pot. I don't see.
Well, I think Ms. Rios still has some money in the estate. that is being, I think there's some money that's being held that was put in the registry of the court mixed with the other monies that belong to the children. I think that's what Mr. Ramirez is referring to, is all the money is in the registry of the court. It's got a mixed element of Ms. Rios's money plus the minor's money.
Okay, my view's been the reason this is all in one pot is because Mrs. Rios should continue to share in administrative costs in the meantime. I don't see it as mixed money. It's not mixed money until it's distributed.
I'm fine with that, Your Honor.
Okay, Mr. Ramirez, with that clarification, do you have any objection to me signing that order for Mr. Reiner?
No, sir.
All right, Mr. Reiner, I don't know that I have access to that order. If you would give me one.
I can send you a file stamp of the application and the order to your email if you'd like that.
Okay, and this order essentially requests that the clerk pay this over to you from the register of the court?
No, I didn't do it that way, but I can change it that it was originally ordered that the administratrix pay it. But I can change it from the registry of the court account.
Ms. Christie, do you have a preference on that one way or the other?
Yeah, I think if I'm ordered to pay it out, then I have to submit a motion to withdraw and get a second set of orders. So I think it's better if it's directly from the registry.
Okay, all right. Okay, Mr. Reiner, I'll sign that as soon as,
I'll revise it.
okay.
Thank you, Judge.
Thank you. If anyone else had anything to say about those attorney's fees and lighting fees,
Oh, Your Honor.
speak now or forever hold your peace, I suppose. Okay,
Judge, we had one other little issue. I know it's not before the court, but I think we need to address it. And that's Ms. Hamrin is still in the case, even though all the damages are being paid by Ms. Rios from the surcharge. And we've all been kind of scratching our head how to get Ms. Hamrin and Allstate out of the case because there's no other basis. So we have a couple of choices. One, we talked about severance, but that's going to be a lot of work. So what we've kind of talked about today is having a motion filed by Ms. Christie to dismiss the surety out of the lawsuit.
okay, again, I had the impression that that was part of the settlement agreement that I approved.
It was, but the fact is they're still in the case until there's an order dismissing. So we recognize that Ms. Hamrin's been courteous enough today to say, yeah, I recognize it's interlocutory, but you know, given that we're not going to be on this case forever, this should be resolved soon.
Ms. Hamrin?
Yes, Your Honor, I think all parties are in agreement that because the court approved the settlement agreement, the mediation agreement, State Farm needs to be discharged and dismissed from the suit with prejudice. And as Mr. Reiner said, it would be interlocutory. And normally, if I thought the surcharge was going to drag on, I would ask for a severance into a separate cause number so that it could become final. But I think the only issue that's remaining is the attorney's fee issue. And presumably that can get set in short order and be resolved fairly soon. So I don't know that it's worth all of the effort for the clerk to have to go ahead and sever it out and create a new cause number. So assuming that the attorney's fee issue will be resolved in the next couple of months, I'm all right with the order of discharge being interlocutory.
You're all right with leaving it being interlocutory? In other words, nobody needs to do anything else for now?
No, we still need to submit an order to the court that officially says State Farm is released on its bond and dismissed with prejudice from the suit. But normally, to make that final, it would have to be severed out.
That's why the severance is, okay, okay. Mr. Ramirez, you have anything to say about this?
I have no problem with that, but only if the cost on preparing those motions, I guess they're asking Ms. Christie to do it, but if they can submit at least a proposed order to her, it'd be easier and save some money for the estate.
Ms. Hammer?
That's fine, Your Honor.
Okay. All right, Mr. Flores, do you have anything to say one way or the other on this matter of dismissing, is it State Farm? I'm sorry, I forget now. Is it State Farm?
I have no objection to that, Your Honor.
All right. Ms. Christie, will that work for you if Ms. Hammer will submit a motion with a proposed order?
So that works. Then she can get the language that she needs in it.
Okay, all right. Anything else? If not, Mr. Ramirez, I'll hear you on your motions, which I noted.
Okay, Judge.
Motion for status and motion to depose. Let me go ahead and, I think you started going into your status. Let's do that first. And
That
then,
one's easier, Judge. That's why I started with that. I think most, like I said, most of those issues have been resolved. I just have questions on, I think there's two other properties that might be listed or not listed yet. I think Ms. Christie might give us information on that. I think there's a lot that had been mentioned that might be landlocked. That's one of them, and I can't forget the other one. I'm sorry. So we need just a status on that.
Mr. Flores, I don't,
I'm sorry, Judge, you froze and we didn't hear you.
how about now? Mr. Flores?
Okay, there you are, Judge.
Okay. I don't know what in the world happened. I didn't do anything different. I don't know that this sales were part of the, well, I'm getting a note here and my internet connection is unstable, so. Well, if if someone will let me know with a hand signal or something, I'll understand. Something's happened. Mr. Flores, I don't remember that the settlement agreement anticipated or that everybody agreed that the administrator would be allowed to sell these properties. Although I think the administrator has legal authority to sell, I don't see the title company going along with it unless your client signs off on it. Is this a viable possibility that your client's going to sign off on sales merely because the title company is going to insist on it before they issue a title policy?
You're correct, Your Honor. The settlement agreement did not speak to selling any property. I think that the parties have talked about getting together, maybe just for a conference call to discuss agreeing on selling properties. And certainly the administrator could apply for an order from the court for a sale. And so I think that's where we left off on that point.
Well, does that answer the question about your request for a status hearing, Mr. Ramirez?
Well, Judge, I thought we had already agreed to sell the property. The only thing we talked about is maybe somebody buying each other out, but Mr. Rayner said no because there's a minor involved, or maybe two now. I don't know if the older one turned 18, but I see his issue. I see his problem. I mean, how can we sell properties? I mean, I'm sorry, how can we switch properties over to each other if one's a minor? So then it has to be sold. All properties have to be sold. We can't have that minor just, acquiring property. So I understood everybody was in agreement, but if there has to be an order, that's fine. Ms. Christie has sold.
I guess the status is that there is no agreement, but Mr. Flores agrees to have a conference with y'all to discuss that. Does that resolve the issue of the status?
Well, that one, number one, yes. I have 4 issues on that. But yeah, I mean, I have no problem with a status. I mean, a conference call saying, yeah, we agree to sell it. Ms. Christie already sold 4 or 5 properties with no issues.
Well, the difference, Your Honor, is that there's no longer a need to sell. I understand that there are no more debts to be paid. So that was the situation with the properties that have been sold so far.
I don't know that I have a role in that.
Your Honor, my concern with keeping properties and swapping properties, certainly we can entertain that, but how do I protect the minor to ensure that property taxes are going to be paid and the property is going to be protected until he turns of majority age? So that was my concern. The court could create a trust. I really hate to create a trust for real property. We still have the same problem of getting the property taxes paid. I have not had the experience in my years in a dependent administration where an administrator can't sell a piece of real property without the heir's signature. Most of the title companies I've ever dealt with only want that decree approving sale.
Well, not exactly an heir, it's the surviving spouse with the community interest property.
Right, well, yeah, and the court can enter an order ordering that property sold despite the spouse. I think there's provisions in the code that they can do that in order to the title.
I agree with that, but I don't,
Yeah.
I've never understood title companies, practically speaking. The only reason those 4 or 5 prior sales that Mr. Ramirez mentioned went through is because she signed off on it. And she
Understand.
signed off on it because she was going to get her half share right off the top, which prevented the access of those funds from
Right.
sharing in administration costs. So we got the whole
Right.
issue. I don't know that I have a role on a status hearing. I mean, the only thing I have that I understand is pending for the courts is your request for attorney's fees for which you have requested a jury trial, Mr. Ramirez. That's the only status that I know of that I have a part or a role in.
Your Honor, if I could back up one moment and just make a comment, if I could. I have no problem entertaining discussions where the minors get cash in exchange for the purchase of property. That would work. And then we'd either put the money in the registry of the court for the minor until he's 18 and protect the minor that way. So if Mr. Ramirez's client and Mr. Flores's client want to buy the minor's interest out and we have appraisals, then I think we could present the court another family settlement agreement for the court to approve wherein the minor's interest would be put in the registry of the court.
Okay, well, that's something you all can continue discussing, I suppose. But
Right.
I don't have a role in that. I mean, that if you all reach an agreement, then my role would be to approve it or not approve it.
Right,
If all parties agree, I'd be inclined to approve it, but I don't have a role right now. I mean,
right. I agree. I think Ms. Christie has gotten appraisals for all the properties. Am I correct, Ms. Christie?
I believe anyone that was specifically requested, we did get. I
Okay.
think back in January.
So I'd be happy, Judge, if we couldn't do an informal discussion, once we had all the appraisals together, you send us to a half-day mediation to see if we could figure this out. And that would conclude the estate fairly quick, Your Honor.
I guess I had understood that if I approve the settlement agreement, the only thing that would be left is a request for attorney's fees. And so I'm kind of misunderstood the agreement. So, Mr. Ramirez, anything else that you need to bring up clarification on the status of the case?
Yes, because Ms. Christie said that all the properties that had been requested or had requested an appraisal have been done. I don't know if there's another property out there that does not have an appraisal. But I thought all of them had an appraisal done, even the homestead.
We did one on the homestead. I don't think that we had one on this, the 6.29 acres. I think we did have one on the landlocked tract that we talked about, but I can send around an updated list. I know you missed that, the one appraisal that we talked about a few weeks ago.
Just because if we're gonna go to mediation on money, we need an appraisal on everything.
I think in the absence of an agreement, I'm gonna end up having to file just an application to distribute the estate out. I think is kind of the alternative in the absence of an agreement otherwise.
What did you mean by it? Just, I forgot the phrase you used, distribution of the estate.
Right, like an application for final distribution of the estate wherein everybody gets their, whatever they're statutorily entitled to.
With regard to real estate, it would be undivided interest holdings.
Right, and so that's kind of the, if we don't reach an agreement, that's logically where we have to go.
I don't see why anybody would object to that.
Well, again, the minor.
Right.
Well, they get undivided interest. No one can sell it. I mean, that's the harsh reality of the end line of this road, which should serve to promote some sort of settlement agreement. Those undivided interest holdings would pretty much tie it up. But anyway, I don't know, but this whole thing of I'm trying to narrow the issue, and the narrow aspect, the narrow view of the issue that I see that remains within the purview of the court is your attorney's fees request, Mr. Ramirez. I sent what you filed as a courtesy to you. I guess anything else status advised that you wanted to get clarified that had to do with attorney's fees.
Only with attorney fees?
Yes, sir.
Okay, I have a request for DCC. It's pending. I know because of COVID and it's hard to set that, but I don't know if you want to set it for early next year just to get some pressure on the lawyers to get things done. I'm not too sure. It's been filed for a while.
Yeah. I don't know, Mr. I don't know what to do because they started doing jury trials. They had one criminal jury trial in Hidalgo County and it did not go well. And they renewed their prohibition against jury trials to the end of October, as I understand.
Do you want to set something in November? Just, I mean, we understand that COVID's going to, probably push that,
Just
but a date to,
50 people, panel full of people. So I'm not anxious to set it for trial in November.
okay.
I don't even know that.
All criminal trials are taking priority, Judge. So they're telling us we're going to get the dregs of anything.
Well, and I'm beyond, I'm the second tier. I'm not even civil court or probate court, civil case jury trial. I'm even beyond that. So I think it's premature, given this matter with COVID and I don't see anything clearing the air anytime soon. It looked like we were getting there, but I guess let me take your request for a docket control conference under advisement. And
Okay.
get back to you. Your motion to depose?
Yes. Judge, the reason I'm asking for a second deposition is specifically in her first deposition, and this wasn't going to be an issue if we didn't have the attorney fees problem now. But in her deposition, and I just sent you an exhibit. I think everybody got it. In her first deposition, she testified that she never got information on the new administrator from her lawyer or anybody else. So she continued to receive cash payments for rentals and keeping them in her house. So that multiplied the work for everybody trying to figure out, what are you doing with this money? How come you're not turning it over to the administrator? So the argument that they have that Doris Rios has through her attorneys is that, look, your work stopped when there was the new administrator, which was Miss Christie. It stopped, the removal issue. Well, I disagree because we had all these issues coming up from the deposition that took months and even years to clear up. And Mr. Rene can tell you how hard it was to go through all those statements and things that she was spending for personal use and money that's missing and never was accounted for. But all that's already settled, okay? What I'm saying is because of the problems that she had or caused, it continued to do my work. Now, I have to explore that with her and say, look, you're telling us that you didn't get word or you didn't even try to contact the administrator. Yes, okay. So then my fees are reasonable. My hours are reasonable based on the code, continuing to the point where I have my last, and I don't have it in front of me, my last amount that I'm charging. So they're saying, no, you didn't do any work, or if you did any work, it was not part of getting the state back where it should be. And I disagree. So I have the right to explore that with her. It's just going to be, you can limit the deposition just to those issues. I don't have to ask her again about anything dealing with the money and where she put the money, what she spent it on, because all that stuff is resolved. I just need a short deposition on, hey, you're telling us that you weren't aware and you kept this money. And then that caused all these problems trying to figure out where the money was and what belonged to the estate and what belonged to you. So for those reasons, I need a short deposition, which they say it's very expensive or whatever. I mean, you can limit it to an hour. I can get this thing done in an hour. So with that in mind, and a second deposition and complicated civil cases is not unheard of. It's just you have to have a good reason to go to the court and ask for relief. So that's where I'm at on that.
Mr. Flores, let me ask you first your response, and then I'll see if anyone else has a thought about this matter.
Your Honor, first of all, I disagree. This is a complicated civil matter. This is the only issue that we have pending is the attorney's fees. And he sounds like he's asking Ms. Rios to, confirm whether he's entitled to those attorney's fees or whether they're reasonable. She can't do that. It sounds like he has all the information that he needs to submit his claim for reimbursement. This deposition is not going to produce any new information and no information that will go directly towards how much or what attorney's fees he incurred. And those issues of whether they're reimbursable or reasonable and necessary, those are issues for the trial. And Ms. Rios is not, she's not competent to testify on those matters anyways. So I really don't see that there's any benefit to taking her deposition. The information he's trying to seek is it's irrelevant and it doesn't go to the issue that's really at hand.
Is there the Texas Rules of Civil Procedure have certain limitations on discovery and so forth? Is there anything about depositions that's specifically discussed in the Texas rules?
Judge, and I should have kept that. I did a quick research a couple of weeks back. I think it's section 192, but it says that it's up to the court, that the court may order a second deposition. And I can look that up again, but it doesn't say specifically, yeah, you're entitled to two depositions. The court may order it if you have cause.
Your Honor, Rule 192 speaks to the court's ability to protect a party from unnecessary discovery. And I cite that statute and several cases in my motion for protection in response to this motion to compel. And I cite that it would be an abuse of discretion to depose a witness who does not have relevant information, which my client does not have with respect to Mr. Montoya's attorney's fees. It's duplicative in that he already has all the information necessary to prove up his attorney's fees. My client is not going to have any new information. It's burdensome. It's going to cost her unnecessary expense. And those are all valid reasons supported by section 192.6 of the Civil Rules of Procedure and the case law to protect Ms. Rios from this unnecessary second deposition.
If I may, Your Honor, Mr. Flores talks about facts. Well, the trier of facts is going to have facts coming in from witnesses. And this is a main witness we have in our case. I mean, she's going to testify what she did wrong and what caused those problems and whether it was reasonable for a lawyer, any lawyer, to look into all those issues and try to get the estate back where it should be, which I think I did, especially when we found out that she was keeping half of the money coming in from the properties. I mean, I had to file motions to put that money back, and it took probably a year or more to get that money back into the registry of the court. So all these issues, she's going to have to testify that they were true. I mean, the trier of fact, if it's a court or the jury is going to want to know testimony from that witness, whether, what caused all these attorney fees after you were removed, and I have a right to explore that.
Well, Your Honor, I believe that the main witness here is going to be Mr. Montoya. He's the one with the claim for attorney's fees, and he's the one who has the burden of proving what attorney's fees he actually incurred, and he has the burden of proving how those are recoverable under the statute that he's making the claim under. And ultimately, the court is going to make that decision whether those are allowable, under that statute. But if he incurred, time and expenses related to activities, obviously he already knows what those activities were. And then it's his burden to make the argument that those are reimbursable under the statute. I just don't see how there's anything more that Ms. Rios could provide. And it's really not her burden, and she really doesn't, she can't really comment on whether or not it's reimbursable or reasonable or not. So it sounds to me like it's really going to be, unnecessary, and the value of the information that'll be recovered from this is not going to outweigh the burden and expense of it.
Your Honor, if I may-
So let me just, before I let you have the final word, let me see if anyone else has any thoughts on this matter.
Okay.
I don't know what your interest, how your interests may be implicated, Mr. Reiner, Ms. Cameron, or Mrs. Christie, but if you have any thoughts, certainly give you an opportunity to share them.
Well, the issue on the attorney's fees is interesting. And, one of the standards we go by is the best interest of the estate for Mr. Ramirez's client. And I believe Mr. Ramirez's client did start the lawsuit. But there's ample case law, Judge, that says that if a beneficiary in error starts a lawsuit that's not brought by the representative, then they can continue and get paid attorney's fees. The issue becomes when the representative comes in the estate, does the heir or beneficiary have any more standing? And that's the cutoff point where the court needs to decide. Mr. Ramirez did provide some value. He did get an early deposition and some other work. So I think as to that issue, you can find a line, if you will call a demarcation of where it needs to cut off. And then as far as moving forward with another deposition, that's going to be the court's discretion of whether they're going to accept another deposition.
Anyone else? Ms. Christie or Ms. Cameron?
No, Your Honor, the estate, it doesn't really have a stake in this since the estate has no liability for any of the fees that they're fighting over.
Ms. Cameron, is that your position also?
Pretty much so, Your Honor. Although, personally, I think it's probably, kind of harassing to depose her twice because I don't think I agree with Mr. Flores that she's not really an appropriate witness for the reasonableness of attorney's fees. But that said, I also see this as dragging out the resolution of this attorney's fee issue and not necessarily on point with respect to the deposition, but I may want to bring up revisit the issue of a severance because with Mr. Ramirez wanting a jury trial, this could go well into 2022 and I just assume be out of the case. So I will probably submit that to the court.
Okay, I thought about mentioning it to you that this was a jury trial that's not going to resolve in 2 months, but rather than complicate the issue, I just kind of let it go. Mr. Ramirez, your final word.
Well, Judge, a short deposition, if you don't want to limit it to 1 hour and Mr. Flores is going to charge you $200 to $300, I'll be happy to reimburse Ms. Rios for $300 to take her deposition. If that's the issue on expense, he's just going to sit there. He's not going to ask any questions. He can if he wants to. So the issue of expense is not there. I'll reimburse them for $300 if they want for that 1 hour. And I'm going to pay all the other expenses of video and the court report and all that. So I don't think that's an issue. Now, I object to Ms. Harmon saying that it's harassing because she's out of the case. She shouldn't have any kind of input on this. This is just she should be out of the case and not have any input. So in a way, if this doesn't settle, we're going to have to wait for trial. So when she's saying it's going to prolong the issue, we're already being prolonged with not having a trial setting. If we've had a trial setting in November, we could resolve in November. We can't because of COVID, I understand. But this thing, if it's not resolved, and then deposition can help in resolving the issues much better. Everybody can close their file without lingering on. So a deposition, I think, would help for either settlement or mediation or anything. 1 hour, I don't think is harassing compared to the damage that she did to the estate. 1 hour, I don't think that's harassing. How about all the harassment she did against the heirs and all the costs that it cost the estate because of her keeping cash and not reporting and going on vacations with the estate money.
All right, Your Honor, I'm going to object to this sidebar comment here. We've already resolved the issue of the liability and damages, and he just doesn't miss an opportunity to try and besmirch my client and make accusations. That's already behind us.
Well, those are facts that came from.
Your objection is overruled. Mr. Ramirez, go ahead and conclude your comments.
Well, Judge, it's just this thing has been on file and yeah, COVID delayed it, but it's been on file since 2016 because of all the issues that came up from her. If she hadn't been the administrator from the beginning, we had a lawyer or somebody else that was competent and could follow the oath that they would take, we wouldn't have all these issues. We wouldn't have all these problems with discovery, all these accounting problems with her money missing from her checks. And when he's saying all these allegations, I mean, she testified to this. She testified in her deposition that she took money from the state and was using the debit card for the estate to go on trips, to spend money on earrings, to spend money on HEB, to spend money on gas, to spend money.
Ramirez, you need to talk to me about why you need to do a second deposition.
So that's what I'm saying, Judge.
That's why you were allowed to do your first deposition in the context of a lot of resistance. I remember this lady really fought the deposition and you,
Judge, I was entitled to that first deposition. I mean, everybody would agree with that.
and you were allowed it, correct?
Right. I mean, that would be automatic appeal issue. You know?
Okay, rehashing all her misdeeds is not helping clarify why you need to take a second deposition.
Well, I just need to resolve the case, Judge, and I think 1 hour would help.
Okay.
If you will.
Anything else?
That's it.
Your Honor, if I could make a comment, I'm assuming that Mr. Ramirez needs a deposition to prove up the work that he and his client have done towards the surcharge suit, because the only issue is attorney's fees. Rehashing all the things that Ms. Rios has done doesn't get him his attorney's fees. He's got to prove up the work he's done to justify the dollars he's asking for. So it should be a limited deposition for those purposes, and Mr. Flores can object to any questions that aren't relevant.
Mr. Flores, remind me the definition in the statute that delineates what kind of attorney's fees are recoverable.
It states code section 351.003.
Yeah, I understand. I have I have the number. There seems to have been specific language, as I recall, as to what kind of fees, like incurred to remove the administrator. There's 1 or 2 things that are described in the statute that Mr. Ramirez would have a right to recover attorney's fees because statutorily he's allowed to get that.
He's allowed, Your Honor, under the section to get attorney's fees for the removal and to bring the case within the requisites of the court. The best case for this is out of Judge Herman's court, Lawyers Surety versus Larson. And essentially it says that you're entitled to attorney's fees for removal and bringing the case within the requisites of the code, meaning correct everything. So at some point, Mr. Ramirez's client was out of the surcharge when Ms. Christie came in. So we've got this finite period, Your Honor, of Mr. Ramirez being able to charge attorney's fees.
So it's like removal or a motion to
Removal and the surcharge.
file an
Yeah,
inventory, file an
Right.
annual accounting
that's correct.
to get the administrative compliance.
Right. So Mr. Ramirez had the
defined by
removal
statute.
part, and he also started the surcharge. And he didn't finish because Ms. Christie came in. So you've got that point where he did the removal, filed his pleadings, and then did the lawsuit. And at a certain point, Ms. Christie was in the suit. And that's where the attorney's fees should be cut off at some point, Your Honor. But the case law is pretty clear. He didn't get the opportunity to bring it in within the requisites of the court because that was Ms. Christie's job to fix the rest of the case.
Okay.
So I think you could do a limited deposition, and if Mr. Flores wants to object to the questions on relevancy, he'll have it. If y'all were in the courtroom, we'd have the same issue.
Well, okay. All right. Let me give it some thought here. Mr. Flores, that's it, right, Mr. Ramirez?
That's it, Judge.
All right, Mr. Flores, on your motion, I guess your motion for protection is kind of the same issue, but so let's go to your motion to compel discovery.
Okay, Your Honor. So as we've been discussing, the central issue of Mr. Ramirez's claim is for attorney's fees. I served some requests for production to Mr. Montoya, asking for him to produce any attorney fee agreements and any invoices or statements that were sent to him for attorney's fees. And those were respondents' requests for production 1 and 2. In response, Mr. Montoya failed to produce any documents under a claim of attorney-client privilege. And to begin with, Your Honor, attorney's fee agreements and attorney's fees incurred are not covered under the attorney-client privilege, and I cite a case for that holding. In addition, Your Honor, even if the court would find that those items are within the privilege, Mr. Montoya has waived that privilege under the offensive use doctrine and under voluntary disclosure. So under the offensive use doctrine, a party waives a privilege if they're seeking affirmative relief, the evidence that they are failing to produce is outcome determinative, and there's no alternative for that evidence. And we meet all those requirements here, Your Honor. He's asking for attorney's fees, affirmative relief. The evidence that he's not producing relates directly to attorney's fees, and there's no other source for that other than Mr. Montoya directly or through his attorney, which he has access to as well. And on the voluntary disclosure, in response to one of the requests for production, and even as an exhibit to his application, Mr. Montoya produced a list of time entries and expenses that support his claim. And presumably those are the same, that's the same information that would be found on invoices and statements. And presumably the fees being charged are in line with an attorney fee agreement that he may have executed. So he's already produced some, if not all, of the information that he's claiming is privileged. And based upon that, Your Honor, we're asking the court to compel Mr. Montoya to produce the documents responsive to those requests for production. And then we are also asking for attorney's fees for bringing this motion. We attempted to resolve this outside of court. I asked Mr. Ramirez to remove the objection and produce documents, and he did not, so I filed this motion.
Floyd's versus Johnson case.
I'm sorry, Judge, we didn't hear the first part.
Okay, I asked Mr. Flores, what are the facts in the Allstate case? Actually, that case says the attorney's employment, terms and conditions of attorney's employment is not protected by attorney-client privilege. I see that as being separate from the billings and statements and stuff.
Yes, Your Honor, there were two requests for production, one for the attorney fee agreement, and then one for the invoices and statements. And so I cite that case to say that the attorney fee agreement is not protected by attorney-client privilege.
Okay. Okay, let's separate the agreement from the statements and billings. Is the case of Republican, the case that you cite for waiver by offensive use, is that a case involving attorney's fees?
No, Your Honor, it's a case involving waiver of privilege.
Okay.
So that's in the alternative that the court would find that those documents are privileged. Even in that event, Mr. Montoya has waived that privilege.
All right, for my purposes, it would be helpful, Mr. Ramirez, if we could split up these two. First, discussing the discoverability of invoices, bills, and statements separately from the discoverability of the employer, the retainer agreements. So let me hear, have you, Mr. Flores, did you conclude your comments on understanding that I want to talk about first the request for production for invoices, bills, and statements, which applicant has received from or that have been generated by an attorney. Did you conclude your comments about that? Because I want to ask Mr. Ramirez's response on that before I deal with the retainer agreement.
Yes, Your Honor, I've concluded.
All right. So Ramirez, you want to respond as to why you don't think you should produce any invoices, bills, and statements?
Well, Judge, I think it's a discretion of the court to order that. I feel that it's privileged information between me and my client.
I mean, you have any case law you want me to review, Mr. Ramirez?
No, Judge.
Okay. I'm gonna read those two cases, Mr. Flores, but talk to me about the retainer agreements. Is there anything else you want to say about that?
No, Your Honor, it's a similar argument to the invoice and statements. I mean, if he's claiming attorney's fees, it's relevant to the discussion what attorney's fees he agreed to pay and whether or not what he's claiming is in line with what he's contracted to pay.
Yeah, I'm a little having trouble with the retainer agreements because the only thing that allows this controversy to be tried is the statutory allowance of recovery. I'm remembering that like retainer agreements in a PI case were back in my time were rarely requested and rarely produced. In a breach of contract, it's kind of a operative fact. That's, that's an element of damage. I don't know where this statutory remedy fits. I don't understand why. Let's assume it's a contingency retainer agreement. Why that would be discoverable? Certainly.
We don't know,
not
Your Honor.
admissible.
I don't know if it is a contingency fee or if he agreed to pay at a certain hourly rate. But if he did agree to pay at a certain hourly rate, then the fees he's claiming should be consistent with that. And there's no way of knowing that without seeing the statements.
Sounds more like a breach of contract. Okay. Mr. Flores, other than those two cases, is there any other case you want to?
No, Your Honor. Those are the only two cases that I'll be relying on for that motion. And you're frozen. I missed that, Your Honor.
I didn't say anything.
Okay.
Okay, these are your, Mr. Ramirez, before I give Mr. Flores the final word.
Same response as to the invoices, Judge.
Okay, again, I don't know what your respective interests, how they may or may not be implicated by this discovery issue, but in abundance of caution, does anyone have anything to say? I'll certainly give you the opportunity to voice any comment. Mr. Reiner?
You're muted, Mr. Ryan.
Your Honor, I don't have any comments on this issue as to the production of his contracts. I think obviously they may be needed for the attorney fee issue. I would just ask we give a deposition, do limiting, and let's move on. Try to resolve this estate so we don't keep it open, because we are harming the estate by keeping it open longer.
Did you say harming or harming? I heard harming.
Harm. Further harm.
HARM.
Yeah.
Ms. Hammer, do you have anything that,
I have nothing to add on the attorney's fee issue, Your Honor.
Ms. Christie?
Likewise, Your Honor, nothing to add.
Judge, if one thing before you finish up, if you have some question on either one issue, the invoices or the contract, if you want to order me to submit everything in camera so you can review and or whatever, and then make an order based on what you see, that's fine. I mean, at least you can review that before there's a production to the other side.
Well, I don't have a problem on the employment contract. If you want to submit it for in-camera inspection because you believe that might help.
Well, I hate for you to have a question on the face of the contract or invoices, whatever, and then have an order where something's.
May I finish what I'm saying, please?
Oh, I'm sorry, Judge. I thought you did.
Okay. I don't have any problem with you submitting your contract for an in-camera inspection if you think it would be helpful. Mr. Flores, if it becomes an in-camera inspection, it'll be made part of the permanent record, and you'll be able, if it's denied, it'll always be there available for appellate review. So I don't see any prejudice to you one way or the other if I get to see it first. So you can do that on the bills and statements. Are you offering to provide the bills and statements that otherwise would be responsive to requests for production, Mr. Rene? What are you offering?
I'm not offering anything. I'm just suggesting that if you want to order something, that might be an option. I'm still sticking to my client.
I'm sorry, I thought you were offering to submit them for an in-camera inspection. Okay. All right, anything else that we need to cover today? From either anyone? Okay, Mr. Ramirez, if you submit proposed orders for my consideration, granting your relief or in denying Mr. Flores' relief, and likewise Mr. Flores, if you submit proposed orders denying Mr. Ramirez relief and granting your relief, can you submit those within 3 days? I'd like to kind of rule on this while it's fresh on my mind.
By Tuesday of next week, Judge?
Yeah, that's fine.
Yes, Your Honor, we'll do that.
Oh, okay. All right, if there's nothing else, we'll be in recess. You all have a nice day.
Your Honor, I'm sorry. I apologize. There is one last thing. I am gonna take up the suggestion on filing a motion for severance to get State Farm out of the case. I'll check with all counsel in advance, but if we can submit an agreed order, I'd prefer to do that and not have to set it for a hearing. If it's an agreed order by all parties, would the court be amenable to just taking it on submission? Uh-oh, you froze, Your Honor. I'm sorry, Your Honor, you froze. I don't know if you heard what I said. I'll attempt to get everybody to agree.
Yes.
Okay, thank you, thank you.
Judge, the only concern is if there's a severance, does that have to go back to the probate judge to give it a new case? Do you have to be assigned that's on that severance also?
Raise the hand. Oh, the judge is on mute. The judge is on mute.
Okay.
Milo, can you hear me there?
Yes, yes.
Okay, I don't know how I went mute, but I'll go back to the assignment order. Usually Judge Herman says all matters having to do with this estate.
Okay. I just wanted to make sure we weren't going down another road.
Same. If it's not going to be a huge procedural issue, then it'd be great to sever it out.
Yeah.
Ms. Hamron, your proposed order would assign, I don't remember this, okay, it would be the next numeric, it would be P dash propose that it be severed and assign P dash 37302 dash A. If there's not already an A, which would be like another ancillary matter.
Right.
That could be your proposed order. And that it include language that all other matters stay in P dash 37302. And well, I don't know what language your severance language needs to be, except to say that P dash 37302 will be the case for the attorney's fees, and the dash A will be, I guess, for everything else. That's kind of backwards, but work with the language to make sure it's clear.
I will, Your Honor.
What the remedy is that you're seeking. And if it's agreed to, I'll be glad to sign it. Okay, I'll leave it at that.
Okay. Well, if we can't work it out, we'll set it, but hopefully we can work it out.
I've understood this by agreement, so I anticipate, I was trying to do something else where if you don't get a response, well, I guess I can do this, Ms. Hamron. If you submit an agreed order, I'll sign it. If you submit an agreed order that doesn't include all the signatures, but includes a certificate of service, I'll sign it within 10 days. If it's not, some motion objecting to it is not filed.
Okay, I'll do that. Thank you, Your Honor.
Got a couple of escape hatches. Okay, you all take care of yourselves. Have a nice day.
Appreciate it, Judge. Thank you
You
for
too,
your
Your
time.
Honor.
Thank you.
All right, thank you.
Bye.